Dear friends, welcome back. And now in this video, we shall be taking a look at some questions that are related to the power of attorney. The 55 landowners are being represented by the township developers, PSCL, and their directors through the instrument of power of attorney. Now, the Power of Attorney Act by itself is a very small act. It is just one page long and it has hardly 5 sections. What is surprising is that although the Power of Attorney Act is more than 100 years old, it took 100 years to realize that the power of attorney was not defined in the Act. And almost 100 years after this Act was enacted, was that definition inserted as Section 1A. Anyway, that is just of historical interest, but it is good to know how the law acts. The question that comes to the mind is, can a company hold power of attorney? Because going back to the Power of Attorney Act of 1982, it has been mentioned that power of attorney is an instrument empowering a specified person. It does not say a legal entity or a company. So how can 55 people give their power of attorney to a corporate entity? Let us see what our conveyance deed says. I reproduce below the exact wordings from the conveyance deed draft. All above 1 to 55 through their power of attorney holder Paranspace Schemes Construction Limited, formerly known as Matrix Developers Limited, in the hands of its authorized signatory Director Mr. Shashank P. Paranspe, duly authorized by the company, and then it quotes a resolution which is to be mentioned over here. So please note, it is in the hands of its authorized signatory and that individual person has been named over here. So it satisfies the condition of the Power of Attorney Act. The next important question that comes to the mind is, what happens if the person who signed a power of attorney or delegated a power of attorney or executed a power of attorney dies? Because according to the Power of Attorney Act, the power of attorney is valid only so long as the person is alive. So what do we do if one of these 55 people is unfortunately not in the world anymore? Does it affect our conveyance deed? We shall have to look at some judgments of the Delhi High Court who have interpreted the law, the judgments of Supreme Court of India, and more recently a Government of India notification which is quoted here and which was published in the Gazette of India on 23rd of February 2007. What it essentially says is that if a power of attorney was executed along with a development agreement, it is valid even upon the death of the donor of the power of attorney. It means the person who executed the power of attorney, even if he is not around in this world, this power of attorney shall still be valid according to this Government of India notification. But let us explore a little further and deeper. The validity of the power of attorney upon the death of the executant is a very important question, and that has been the subject matter of many cases on which there have been virtually similar pronouncements by the court. It deals essentially with the provisions of the Indian Contracts Act, specifically Chapter 10, the title of which is Agency, and the particular section in question is 202. It says that the power of attorney is irrevocable if given for valuable consideration or to secure the interest of the donee. The donee is the person who is named in the power or who is the power of attorney, which in this case is PSCL's director, and it has been given for a valuable consideration. In other words, it is the people who have executed the power of attorney have been compensated in terms of money or other considerations which have value. So basing this as the foundation, let us look at a few important judgments. The Supreme Court, way back in 1969, and I have given the reference here of the All India Reporter, said that if an agency was created for valuable consideration, the POA cannot be revoked. The second case that we can see is the Delhi High Court case, which has been quoted a number of times in various other judgments. Therefore, I'm quoting this particular case because this happens to be the fountainhead of other judgments. And it says that commercial transaction cannot be frustrated on account of death of the executant of the power of attorney. A power of attorney given for consideration is valid even after death. So please take a note of that. And that is the answer to our question. That is a power of attorney valid after a person dies? The short answer is yes, it is valid because all these powers of attorney have been given for a consideration, which means either money or some other considerations which have value. So you should have no doubt in your mind that the power of attorney will be valid even if any one of those 55 people is not alive. I'm repeating this so that the message is clear in our minds. So friends, that brings us to the end of this lesson. And now in the next lesson, we shall be taking a look at another question which is of great importance, which is conflict of interest. So until then, bye-bye, and thank you very much once again for your attention.